All right, Mr. Schmidt, Mr. Pruitt.
Your Honor, he's going to speak with Mr. Martinez.
Okay, do we have someone else that's trying to question
I
this?
need to make two announcements. On the top of page 9, we had Michael Bowman. He was set for a plea today, but he took one week before last. So that was an error.
Said he pled last week.
Yes, sir.
Okay.
And then on Brian Morris on page 10, he had been in Kaufman County. He was transferred to Smith County on the 14th. And Mr. Schmidt said he was not ready on his case, and so not to bench warrant him from Smith.
What's his name again?
Brian Morris on page 10.
Just need to reset now.
Yes.
Our interpreter needs to apply. So. Mr. Schmidt, Martinez, is he ready?
Okay, here comes Mr. Schmidt.
I don't have my interpreter yet. I don't think so.
Okay.
So with that,
But we have a 2 and 2:30.
We could probably squeeze in Mr. Pruitt. We could probably do that. I don't see.
Like,
Yes.
yeah, so Pruitt's ready.
One of Mr. Pruitt. That'd be fun.
We're gonna need him out of the tank with that paperwork. Yeah. we need-
All right, we are back on the record. CR 22-45, State versus Warren Clay Pruitt. Mr. Pruitt, if you raise your right hand, raise your oath, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can lower your hand. All right, Mr. Pruitt, your name is Warren Clay Pruitt, correct?
Yes, sir.
Mr. Pruitt, are you a United States citizen who reads, writes, and speaks English?
Yes.
And you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes.
Is there anything about the paperwork that you signed, Mr. Schmidt, that you don't understand?
No, sir.
Okay. Mr. Schmidt, you believe Mr. Pruitt to be competent today, and if so, he's entering into this plea intentionally knowingly voluntarily.
Yes, sir.
All right, Mr. Pruitt, you are charged by indictment with theft of livestock less than 10 head, value of less than $30,000. That is a state jail felony. That does carry a range of punishment, not less than 6 months or more than 2 years in a state jail prison. It also carries a potential fine not to exceed $10,000. I see that there is a plea agreement in your case. It appears that you would plead guilty to that crime. And the state would recommend that your punishment be set today at 8 months confinement in that state jail division of prison, a $1,000 fine, plus court costs of $290 and reimbursement fees of $105. And the state would be dismissing a multitude of cases associated with this. Let's see, theft less than 10 head of livestock, false statement to law enforcement, things of that nature. Is that your understanding of the agreement?
Sir.
And Mr. Pruitt, pursuant to this agreement, you would also receive credit for the time that you've already spent in jail, which would be 245 days. You would get credit towards that 8 months of the time that you've already spent in jail. So with the understanding of that plea agreement, understanding the range of punishment, you still wish?
Yes, sir.
Okay. All right, so Mr. Pruitt, I would ask you, how do you plead to theft of livestock less than 10 head, less than $30,000? Guilty or not guilty?
Guilty.
Are you pleading guilty to that crime because you are guilty of having committed that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, or substantive offense, plead guilty, Mr. Schmidt. Any objection to the admission of stipulation of evidence?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial knowledge. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
Nothing further.
Motion to review the evidence. Man, I don't have a simulation of evidence. You have one there with you. If so, can you read it to the court?
Yes, sir. Yes. On or about May 26, 2021, in Van Zandt County, Warren Pruitt was selling cattle at the Emory Cattle Sale when he was confronted by deputies with Van Zandt County Sheriff's Office. They had video surveillance of him and someone who was directing, or who he was directing, removing the tags from 5 cows and a calf that was stolen from Jesse Everett.
All right, thank you. All right, based on the evidence agreed to by the defendant, the state and admitted court finds that there is enough evidence to convict Mr. Pruitt of this offense. The court does follow the plea agreement state and convicts Warren Clay Pruitt of theft, less than 10 head of livestock, less than $30,000 value. The court on the state jail felony assesses punishment at 8 months confinement in the state jail division of TDC. Orders Mr. Pruitt to pay a $1,000 fine, $209 court cost, $105 reimbursement fees. Court dismisses under section 1245. Case is laid out as indicated on the judgment. So the agreement, the court awards Mr. Pruitt 245 days credit towards the time already spent in jail in this case. Mr. Pruitt, you're hereby remanded to the custody of the sheriff so we carry out the terms and conditions of the sentence. Whenever you are released from TDC, it is important that you return to the Van Zandt County Courthouse to make arrangements to pay for your fines, court costs, reimbursement fees. Failure to do so will result in you being rearrested for your failure to pay. You understand? Okay. All right. Go ahead and step over with the deputy to be.
Do we have the interpreter on right yet, or can I knock a couple more of these out?
Well, when you said interpreter, she popped in. So she said,
Mr. Sosa, he's first.
That's correct. Well, when are we doing Mr. Cespedes? Okay, so if we can reset Mr. Sosa, we have Mr. Cespedes who needs a translator as well, but we have to go over the paperwork, so.
But he's set for 2:30, so.
who are we going with first? Cespedes?
No, Mr. Sosa.
Want to bring in this bill?
Later.
Wally, are you seeing both English and Spanish on your side?
I do not see that it's active yet.
Yeah, I think the reason is because we were on this morning, Maria was here. So I think what I'm going to do is I'm going to stop this interpretation and then just restart it for whatever reason it's not allowing me to authorize you. So let me see if I can.
Okay.
End it and then restart. Molly, I'm gonna go ahead and swear you in before the test. All right, if you'll state your name and your license number for the record. All right, raise your right hand. Ms. Field, you solemnly swear or affirm that you will make a true translation of the statements of the court, questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment. So help you. And our first defendant is going to be Sosa, customer CR 23-00132. This Abraham is the Richard, can you just move the laptop? We can't see the defendant's face. I don't think Holly can mic up for the
We don't have that.
It's either that or turn on the computer.
I don't think
Turn the camera on.
camera's not.
All right, there we go.
Okay.
Holly, let me know when you're ready. Okay. All right, this is cause number CR 23-00132, State versus Sosa. Mr. Schmidt, I think Mr. Sosa is set today on free trial. Go ahead.
That's correct, Judge. We're gonna ask for an additional pretrial setting. I've been discussing this case with Ms. Curry. There are multiple co-defendants that I've been in touch with and talking to, and I currently represent. So what we're trying to do is get all the evidence together at one time. So at this point, we'd ask just for an additional pretrial setting to make sure everybody's on the same page. And if the state has no objection, I'd ask for that October 24th date for that.
Stating the judgment.
Sorry, Your Honor, I couldn't get my mouse to work. No objection.
All right, there being no objection, the court grants the defendant's request for additional pretrial hearing. We set that on October 24th. Let's just set that at 2 p.m. Mr. Schmidt.
Yes, sir.
For our interpreters.
Judge, is it possible to do 2:30? And the reason why I ask is that generally speaking, when I get over here, I'm doing a lot of paperwork and then we have to stop.
Let's do 2:30. All right, we'll see Mr. Sosa back October 24th, 2:30. Mr. Sosa, do you have any questions for Mr. Schmidt?
Está bien.
Okay, all right, maybe so we're adjourned in this. All right, Holly, thank you very much. So I understand you're gonna slip away and something else. Get in at 2:30. I think that the next one's gonna be a plea. I think we're working on paperwork, so unfortunately not ready yet. Thank you, ma'am. See you soon. Castle, how are you, sir?
Good, Judge, how are you?
Oh, I'm doing well. Oh, there you are. Okay. This is cause number CR 23-114, State versus John Raymond Minutes for pretrial. Go ahead.
We don't have any pretrial at this point, Your Honor. We did receive a link to the discovery portal that had some updated information in it, just a video that we downloaded, but that's it. I think we've received everything at this point.
Okay. All right. And do you anticipate the need for an evidentiary hearing?
I do not, Your Honor.
Okay. All right, then what we'll do is we'll set this for docket call. Give you time to work with the state to see if we can reach a resolution. If not, then on that day, we can discuss any other pretrial issues or just set up a trial. So I'd be looking to set in October, do you have your calendar available?
Your Honor.
Got a couple dates in October. I've got 10th, 12th, 10th, 12th, 24th. Those are Tuesdays.
Did you say the
10th,
10th or the 12th?
24th.
10, 12, or 24.
Probably the 24th, Your Honor.
Okay. All right, court says Mr. Benz for adopting ball, October 24th, that'll be at 1:30.
All right. Thank you, Your Honor.
And Mr. Benz, if you make bond, on the 24th, your hearings will be at 9 a.m.
Yes,
Okay,
sir.
if you're out of jail in October, then come to court on 10/24 at 9 a.m. Okay?
Yes, sir.
All right, thanks, sir.
All right. Thank you, Your Honor. That's all I have. Maybe excused.
Thank you, Mr. Castle. Good to see you.
Thank you, Your Honor. You too. Appreciate it.
Okay, we need just a few minutes, sir.
You got it.
Thank you, sir. Uh-huh. Your Honor.
Yes, Jim.
All right, I think we're ready.
All right, I'm bringing Mr. Vargas.
Good afternoon, Judge. This is the interpreter.
Hi, Mr. Vargas. Give me just a second. I'm gonna get you set up.
All right.
All right, Mr. Vargas, do things appear to be set up correctly on your end?
Hey. Okay. Sí, lo escucho.
Excellent. Okay, all right. So first order of business, Mr. Vargas, what I'm gonna do is have you state your name, your license number for the record. Thank you, Mr. Vargas. Sir, if you'll raise your right hand, I'm gonna now place you under oath. Sir, do you swear or affirm that you will make a true translation of the statements of court, the questions of counsel, and the testimony given by the witness in the matter now on trial to the best of your skill and judgments of the God? Okay, all right, this is cause number CR 21-382, State of Texas versus Pedro Luis Cespedes. And I believe that Mr. Cespedes was set for pretrial today, Mr. Schmidt, but it's my understanding that he has reached a plea agreement with the state. Is that correct?
That's correct.
Okay. And before I go any further, it looks like the plea agreement is that Mr. Cespedes would plead guilty to a third-degree felony offense of engaging in organized criminal activity. And the recommendation is that the court review the evidence, not convict Mr. Cespedes, but rather placing him on 5 years community supervision and assess a $2,000 fine plus court costs and reimbursement. Is that correct, Mr. Smith?
That is correct.
All right, and is there any immigration issues or anything that we're gonna encounter during this plea before we go any further?
Judge, I've discussed the immigration status with Mr. Cespedes on multiple occasions. He informs me that he has no concerns about immigration and that he was a Cuban national and he's here lawfully. So I've explained that to him through an interpreter several times, and he's told me that he's comfortable going forward.
Okay. All right, Mr. Cespedes, if you'll raise your right hand, I'm gonna place you under oath. You'll raise your right hand.
No, okay. You can't hear it? He can't hear.
Mr. Cespedes, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sí, juro.
All right, thank you. You can lower your hand. All right, Mr. Cespedes, You're not a United States citizen, are you? You have to answer out loud.
No, no soy ciudadano americano.
In the record reflect that Mr. Cespedes, if he does speak and understand English, he's being assisted today with his natural language of Spanish with the assistance of a licensed court interpreter. Mr. Cespedes, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt's representation?
Sí, estoy muy contento con eso.
Do you understand all of the paperwork that you read over and signed today with Mr. Schmidt?
Sí, estoy de acuerdo en respetar todo lo.
Mr. Schmidt, do you believe Mr. Cespedes to be competent today?
I do, Judge.
You've explained to him regarding this case and specifically the advantages and disadvantages of a deferred plea.
Judge, to the best of my ability through interpreters who speak Spanish, I believe that I've thoroughly explained the pros and cons of deferred as well as his legal rights and his waivers, and received sufficient feedback to believe that he understands those and is ready to proceed.
Very well. Mr. Cespedes, you are charged by indictment with a third-degree felony offense of engaging in organized criminal activity.
Judge, we're having technical difficulties.
I think we've lost our connection. Fabio. Will you see what he's hearing? I think we've lost our connection. It just keeps spinning saying we're connecting to, okay, we're back.
All right, then you stand right there and you hold the laptop that very
Don't move us, we're playing still waters, quiet waters.
Judge, I don't know at what point he no longer could hear us.
Let's ask him, whenever we get it connected, we'll ask him to repeat to the interpreter.
Yes.
So Mr. Vargas, if you can communicate with Mr. Cespedes and ask him, what is the last thing he heard in this proceeding?
Si estaba de acuerdo en respetar los acuerdos.
Okay. So he heard pretty much all of it. Okay, so let's start here. Mr. Cespedes, you are charged by indictment with a third-degree felony offense of engaging in organized criminal activity. You all still having connection issues?
I don't know.
No, he can hear.
Se escucha poquito.
Poquito. A little bit, he's hearing just a little bit.
Que se me acusa de participar en.
Okay, and the range of punishment for that criminal activity is a prison sentence that cannot be less than 2 years or more than 10 years if you were put in prison. But the plea agreement today is for you to be placed on community supervision, also known as probation. And that would be for 5 years. You would have to pay a $2,000 fine, court costs of $290, reimbursement fees of $585. Is that your understanding of the plea agreement?
Wait just a moment.
Tengo que pagar. No escuché la suma.
You heard everything up to the dollar.
Okay.
connecting again. So
All
I'm
right.
on the hotspot. I'm gonna try my hotspot. Hang on just a second.
Or we can just do this though. Let's do this. Let's just shut that laptop down, take the headphones off of it. And I'm gonna have Mr. Vargas stay in English channel. We're gonna do it in a second. Let's stay where we're at here in the English channel. And I'm gonna start back over with the plea agreement, just to make sure he's heard everything. Okay, so I'll chop it up for you, so it'll be easier for you. Mr. Cespedes, you are agreeing to be placed on probation for a period of 5 years and pay a $2,000. Also, you are agreeing to pay court costs $290 and reimbursement fees of $585. Mr. Cespedes, you understand that if I approve this plea agreement and you violate any of the conditions, I could revoke the plea agreement and put you in prison anywhere from 2 years to 10 years.
Sí, entiendo.
Then, Mr. Cespedes, I'm going to ask you for your plea at this time. How do you plead to the crime of engaging in organized criminal activity? Guilty or not guilty?
Bowden.
And Mr. Cespedes, has anyone forced you to plead guilty here today, or are you doing that on your own free will?
De manera libre y voluntaria.
Thank you, sir. Court will accept the defendant's plea of guilt at this time. Mr. Schmidt, do you have any objection to the admission of the evidence?
No objection.
Court admits the evidence and takes judicial notice of the defendant's judicial confession. Is there anything further from the state in this matter?
No, Your Honor.
Mr. Schmidt, is there anything further from the defense?
Nothing further, Judge.
Mr. Schmidt, I do not have a copy of the stipulation of evidence here in my plea packet, so I'm going to ask that you do two things. That you read it to me and you read it slow enough that Mrs. Grisham can type down, and slow enough that Mr. Vargas will be able to retain that. And read it to Mr. Sims.
And Judge, unfortunately, right now, I don't see that stipulation in the packet. I believe that I had a copy of it, and now I believe I left it in my office in my haste to try to meet the interpreter. So I would ask that the state provide that to the court, and I apologize. And then ultimately, we also would probably need a copy of that sent to the jail from Mr. Cespedes' signature.
Harwell, can you assist us?
Yes, Your Honor. So the stipulation reads, on or about February 5th, 2020 in Van Zandt County. Mr. Cespedes was working with Leonel Perez and Joel Rodriguez to put credit card skimmers on gas pumps.
Hang on, Mr. Harwell. Yeah, let him finish, give him a second, so the audio can switch, then you go. So, go ahead and proceed.
The three suspects.
I can't hear you. Can you hear him? Are you in the English channel or let's try it now.
Right. Can you hear me now, Your Honor?
Then go ahead.
Okay. The three suspects were stopped at Mr. D's gas station in Van Zandt County and opened the door of a pump with the intent to install a credit card skimmer. Nothing further, Your Honor, and I'll work on getting that emailed over.
Mr. Schmidt, are you hearing the interpreter?
I can read your lips, Your Honor. We don't have any objection, but I can't hear you.
Miss Taylor,
Now I can.
yeah. No, Richard, can you just on the laptop on Zoom, go down to the interpretation tab where it says English and just go back to your original audio. Put that over to your original audio, get off the English channel.
The laptops. Yeah, you say on laptop, but that's already closed down.
I did.
Okay, can you hear me better now?
Yes.
I think we were still going through two different channels. That's why we couldn't hear Mr. Markle.
Okay. So to answer the court's question, we heard the stipulation and have no objection to the state's recitation of the facts. I believe that'll be memorialized in writing, and we will provide that with the packet before he leaves here.
Are you hearing the interpreter?
No.
Mr. Vargas. Mr. Vargas, I think you'll need to switch out of the channels. Here, let me see.
Okay,
Now we're better. Okay, so
yes,
let me repeat what I think Mr. Schmidt said. Mr. Schmidt indicated that he had no objection to the state's recitation of the stipulation of evidence, and they would get that form over for Mr. Cespedes to sign.
sí, el juez repite que el abogado dijo que pudo oír las estipulaciones tal como fueron recitadas o leídas por el fiscal y que va a esperar que le envíen el texto para la firma del acusado y su firma.
And I have the document here, and it says what the state has already said, so we're going to sign that.
Dice, ya tenemos el documento en nuestras manos, dice lo que ya el fiscal dijo, por lo cual procedemos a firmar.
All right. Then, this will be the last portion. Based on the evidence presented to the court finds that there is enough evidence to convict Mr. Cespedes of his offense.
Bueno, ahora pasamos a la última fase de la audiencia y es basado en las evidencias que están ante mí, hay suficiente como para determinar la culpabilidad del señor Céspedes.
Court does follow the plea agreement and places Mr. Cespedes on 5 years community supervision.
Y este tribunal va a cumplir con el acuerdo negociado, por lo cual se ordena que el señor Martínez Céspedes esté ahora en libertad condicional por 5 años.
The court orders him to pay a $2,000 fine, $290 in court costs, and $585 in reimbursements.
Y le ordena que pague una multa de $2,000, $290 por reembolso del costo del proceso y $585 en reembolso de honorarios y gastos.
Mr. Cespedes, you are remanded to the custody of the Van Zandt Probation Department.
Señor Pérez, ahora a usted se le ordena pasar bajo la supervisión del Departamento de Libertad Condicional del Condado Van Zandt.
They're going to tell you more information about what to do next. Please step over with the police officer to be fingerprinted.
Ellos le van a decir lo que a seguidas usted debe cumplir y hacer. Por favor, vaya con el alguacil o policía que está ahí.
All right, Mr. Vargas, that was a little choppier than we wanted to do it, but I appreciate you hanging in there and getting through
No
it.
problem. The easiest thing sometimes is just to drop the interpreting and do consecutive.
Yeah, what I'm gonna work on is maybe getting a hard line, internet connection in there, so we don't have that delay, so I appreciate you working with us today. Thank you.
Whichever way you choose, we are there to serve you, sir.
Thank you, sir, I do appreciate it.
Thank you. Goodbye.
All right, Mr. Schmidt, you ready on anyone else, or do you need some time?
Yes, Christopher Green.
All right, Mr. Green, you'll come up, sir. This is Christopher Adam Green, files number CR 18259. And are we doing a plea today, Mr. Schmidt?
Yes, sir, we are.
All right, I don't see that I have any plea paperwork here. Can you tell me what the terms are?
Judge, we're pleading under section 1244B, Texas Penal Code. Punishment's going to be assessed at 150 days in the county jail with credit for 150 days. 0 fine, 180 restitution to DPS lab, court costs, and $585 in reimbursement fees.
What were the court cost amount?
$270.
Any 1245s?
No, sir.
All right. And original charge was state jail plus one, correct?
Correct.
All right, Mr. Green, raise your right hand, sir, and place your oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you can lower your hand. Your name is Christopher Adam Green, correct? And Mr. Green, are you a United States citizen who reads, writes, and speaks English?
Yes.
And have you ever been diagnosed with any kind of mental condition?
Do you understand the question? Yes.
Yeah, can you tell me about that? Can you tell me what you've been diagnosed with? Just the best that you can remember.
Brain damage.
Brain damage. Are you currently on medication or seeing a doctor or anything for that?
No.
Okay. Do you feel like, Mr. Green, that despite the brain damage that you've had, that you're able to understand Mr. Schmidt and understand the court and you understand what's going on here today?
Yes.
Okay. And Mr. Schmidt, as your attorney, are you pleased with him as your attorney?
Asking if you're happy. Yes. Yes.
And you feel like you've been able to talk to him about your case and you understand everything that you're doing today and you don't have any more questions, is that right?
Yep.
Okay, Mr. Schmidt, do you believe Mr. Green to be competent to enter into this plea?
I do believe he's competent, Judge, yes.
You explained to him his rights that they pertain to this case, correct?
Yes, sir. I have.
All right, you believe that he entering into this plea intentionally, knowingly, and voluntarily?
I believe he is, yes.
All right, Mr. Green, you are charged by indictment with a state jail felony offense of possession of a controlled substance, penalty with 1 less than 1 gram. However, the plea agreement today is to a reduced charge under section 12B. That is a classic misdemeanor, which means the maximum you could be put in jail would be up to 365 days and a fine that cannot exceed $2,000. I've heard Mr. Schmidt tell me that the plea agreement is that you're going to plead guilty to that class A misdemeanor or that state jail felony offense, which will be reduced to a misdemeanor class A, and that your sentence would be 150 days in the county jail. You would receive credit for 150 days for the time that you've already been there. Plus, you would pay restitution, you would pay court costs, you would pay reimbursement. That's your understanding of the plea agreement too. Is that right, Mr. Green?
Yep.
Okay. All right, then, Mr. Green, how do you plead to possession of a controlled substance of 1 less than 1 gram in class A?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yeah.
And has anybody threatened or forced you to plead guilty?
No.
All right, court does accept the defendant's plea deal. Mr. Schmidt, any objections to the stipulation of evidence?
No objection.
All right, court admits that in evidence, takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
No, sir.
All right, and can the defense read the stipulation for me?
Yes, sir. On or about March 4th, 2018, Van Zandt County. Mr. Green was walking in the middle of Highway 64. He was stopped by Deputy Everett, who made contact to see if he was okay. During the interaction, Mr. Green had indicated that he was hallucinating. Deputy Everett placed Mr. Green in hand restraints, patted him down, found a lighter in his pocket, and ultimately Mr. Green told Mr. Deputy Everett that he had something in his front right pocket. Turned out to be 0.42 grams of methamphetamine.
Thank you, Mr. Schmidt. All right, based on that evidence, court finds that there is sufficient evidence to convict Mr. Green of this offense. The court does follow the plea agreement. Court convicts Christopher Adam Green of possession of controlled substance, penalty group 1 less than 1 gram. Court allows the prosecution under section 1244B, assesses punishment on that class A misdemeanor at 150 days confinement in the county jail, issues credit for 150 days time served, orders a $180 restitution payment, $585 payment for reimbursements, and $270 court costs. Mr. Green, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Mr. Green, when you do get out of jail, you have time, I want you to come up to the Van Zandt County District Clerk's office and talk to them about paying for fines, court costs, and those things. If you can't pay it all at once, ask them what you can bring and see if they can set you up on a payment plan, okay? Does that make sense?
Yeah.
Okay, all right.
In here? No, it's in here. Okay, so you'll be bringing, you want. Okay. Okay.
All right, thank you, Mr. Green. Go over and see the deputy to be fingerprinted. Who's next?
Kobe Herron.
Kobe Herron, CR 23-98. All right, Mr. Herron, go raise your right hand. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you, sir. You can lower your hand. All right, your name is Kobe Alton Herron, is that correct?
Yes, sir.
Mr. Herron, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with the representation of him?
Yes, sir.
Feel like you had enough time to talk with him about the case and all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today or this plea agreement that you do not understand?
Anything you don't.
Oh, no, I understand it all.
Understand it all? Okay. Mr. Schmidt, do you believe Mr. Herron to be competent? And if so, then he's entering into this plea intentionally, knowingly, and voluntarily.
I do on both counts, Judge.
All right, Mr. Herron, you are charged with prohibited substance. Is this a reduction at all? I can't tell.
It is, Judge. He was originally indicted on a prohibited item in a correctional facility. We were pleading to attempted possession of the prohibited item in a correctional facility, which is.
All right, Mr. Herron, the plea agreement today is for you to plead guilty to a lesser offense of attempt to commit prohibited substance or item in a correctional facility. That is a state jail felony that does carry a range of punishment of not less than 6 months or more than 2 years in prison. Plea agreement appears to be that you would, upon your plea of guilty, accept a punishment recommendation of 9 months in state jail, along with $55 reimbursement fees and $290 in court cost. And as part of the plea agreement, you would receive 181 days credit towards that sentence. Is that your understanding of the plea agreement?
Yes, sir.
All right. Understanding all of that, Mr. Herron, how do you plead to attempt to commit prohibited substance or item in a correctional facility?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Did anyone threaten to force you to plead guilty?
No, sir.
All right, court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the admission of the stipulation of evidence?
No objection.
That is admitted and the court takes judicial notice of Mr. Herron's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
No, sir.
And I still don't have any stipulations over here, so can you
Yes, sir.
read that slowly enough, description?
Yes, sir. On about March 7th, 2023, Van Zandt County. Mr. Herron was an inmate here at the Van Zandt County Jail. During his stay, he attempted to obtain contraband, a cell phone charger, and took steps beyond mere preparation to obtain the cell phone charger.
Thank you, Mr. Schmidt. And I'm assuming that cell phone charger is a prohibited item as defined by statute.
Yes, sir.
All right, then based on the evidence, court finds that there is sufficient evidence to convict Mr. Herron. The court will follow the plea agreement today. Court convicts him of the state jail felony, attempt to commit prohibited substance or item in a correctional facility, assesses his punishment at 9 months confinement in state jail, awards him 181 days credit towards his sentence for time already spent in jail. Court orders him to pay $290 court cost and $55 reimbursement. Mr. Herron, when you are released from TDC, you need to appear at the courthouse and make arrangements to pay your fines and court costs. Failure to do so will result in issuing another warrant for your arrest. You're hereby remanded to the custody of the sheriff, so we can carry out the terms and conditions of the sentence and have you step over to me. Who's next?
Richard Bowden.
Mr. Bowden. This is cause number CR 22-353, St. Francis Richard Raymond Bowden. Is today going to be a plea as well, Mr. Schmidt?
It is, Judge. If the court will recall, we previously announced ready for trial. Mr. Bowden has been on the trial docket for a little bit. I've been continuously negotiating with Ms. Curry, and we're prepared to proceed to a plea.
But what's the terms of the plea?
Judge, Mr. Bowden is prepared to plead guilty to a lesser included assault, family violence, class A misdemeanor. Punishment to be assessed at 256 days in the county jail. He's got 256 days credit, $1,000 fine, $270 in court costs, $585 in reimbursement fees. In addition, the DA is going to take under 1245 DA 2022 892 and DA 2022-950.
All right. Mr. Bowden, if you raise your right hand on the place under oath, sir, do you swear that the testimony you give to the court today, the truth, the whole truth, nothing but the truth, so.
Do.
All right, before you begin, Mr. Bowden, your name is Richard Raymond Bowden, correct?
Yes,
And, are you a United States citizen who reads, writes, and speaks English?
yes, sir.
Have you ever been diagnosed with a mental condition?
Don't have.
You're represented by Mr. Richard Schmidt. Are you pleased with him as your attorney?
Very.
Do you feel like you've had enough time to talk with him about the case and have all of your legal questions answered?
Yes,
You've signed paperwork here today. Are you telling me that you understand everything that you've read? And something?
yes, I do.
All right, Mr. Schmidt, do you believe Mr. Bowden to be competent today? And if so, that he's entering into this plea intentionally, knowingly, voluntarily?
Yes, sir.
All right, Mr. Bowden, you were originally charged with a first-degree felony offense of aggravated assault with a dating relationship, family, or household member with a weapon. However, the plea is to a lesser included assault, family violence, class A misdemeanor, which would carry a range of punishment not to exceed 365 days in the county jail, nor a fine to exceed $4,000. You've heard the plea agreement read by Mr. Schmidt into the record. Understanding the plea agreement and the range of punishment, you still wish to go forward, correct?
Yeah.
Mr. Bowden, how do you plead to assault, family violence, class A misdemeanor?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Does anyone threaten or force you to plead guilty?
No.
Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Any kind of victim compliance, victim impact, tracking, or any issues like that? Victim solving?
Let me double check real quick, Your Honor.
Anything further from the defense?
Nothing further, Judge.
All right, Mr. Schmidt, you have a stipulation of evidence there, and so you cite that to the court.
Yes, sir. On or about July 17, 2022, Van Zandt County, Mr. Bowden caused bodily injury to LaWanda Bowden by pushing her, and they were married and living together at that time.
Thank you, Mr. Schmidt. Mr. Harwell.
Your Honor, state is in compliance. No victim impact statement was received.
All right, thank you, Mr. Harwell. All right, then based on the evidence presented, the court finds that there is sufficient evidence to convict Mr. Bowden. Court follows the plea agreement. Court convicts him of lesser included assault, family violence. Assault, family violence, class A misdemeanor. Assesses punishment at 256 days in the county jail. Issues him credit for 256 days time served. Orders a $1,000 fine, $270 in court costs, $585 reimbursement fees, and the court dismisses under section 1245, DA 2022-892, and DA 2022-950. Mr. Bowden, you hereby remanded to the custody of the sheriff to carry out the terms and conditions. Please step over to be fingerprinted. Once you are released, you do need to make arrangements here at the courthouse, here at the district clerk's office to pay your court costs, fine, and reimbursement. Failure to do so will result in the court issuing a warrant. Who's next?
Evans.
Sean Corey Vance Evans, CR 19-14.
That's correct, Judge.
Doing on Mr. Evans' case today.
Judge, we are here on state's motion to revoke. We've been in discussions with the DA's office as well as the probation department. And we have all reached an agreement to withdraw the state's motion to revoke, continue Mr. Evans on community supervision with the amendment that he is to submit himself to an inpatient rehab facility within 30 days of release from Van Zandt County Jail. Upon release from the inpatient rehab, he's going to be on ISP. And he will be ordered to pay additional attorney's fees for these proceedings.
Mr. Evans, if you'll raise your right hand, I'll place you on oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, Mr. Evans, the court has you on supervision right now. Tell me in your own words why the board should entertain this agreement and not do something different.
First of all, Your Honor, I struggled with sobriety during my terms on probation. I was doing pretty good for the last 2 years, and then my brother was murdered, and I kind of got thrown off kilter. But I understand that that's not a reason to violate the rules and terms of my probation. But I made a mistake, and my wife is has sought out a place for me to get some help and some coping skills so that this won't happen ever again.
Okay, well, I'm sorry for your loss of your brother. You understand that the state and court are giving you an opportunity here, if I follow this agreement, that a lot of things you're going to have to be in charge of when you get released. A lot of times when we send people to rehab, we send them to rehab that's run by the prison system. So it means we keep you in custody, we make you go, put you in there, and then whether you stay or not, it's up to you. You understand this agreement, you're going to be let out of jail. It's going to be on you to seek out that place, get there, do your rehabilitation, and work on this. Do you understand that, right?
Yes, Your Honor.
Okay. All right. So, Mr. Evans, I'm going to give you that opportunity. I'm going to approve the agreement today. The court will grant the state's motion to withdraw. Its motion to revoke. The court will amend the conditions of community supervision to include an inpatient rehabilitation program, placement on ISP after completion of rehab, and $500 in new attorney fees for the filing of this motion. Court will continue Mr. Evans on community supervision. So I hope that you get the help that you need with the scope and skills in rehab. And I know that that's going to be it's going to be a struggle for you because the grief that comes with a loss like that is something that doesn't go away. So I hope that you really can lay your hands on some skills in rehab. So go in there with no mind and see if you come out a better, stronger man. Okay?
Yes, sir. Thank you.
All right, we'll see you soon. Who's next, Mr. Smith?
Jeremy Hester.
Jeremy Wayne Hester, CR 21291. All right, Mr. Hester is set for docket call today.
That's correct, Judge. I've been in conversations with Ms. Curry as well as other individuals, and we are making some progress towards a resolution on Mr. Hester. That's going to require some additional time. We would ask for another docket call on him on that October 24th date. Hopefully we'll get into the right position pretty quickly.
Objection from the state.
States in agreement, Your Honor.
All right, court will grant Mr. Hester an additional docket call on October 24th. That'll be at 1:30. And Mr. Schmidt, I will just note that I think this is today was the 10th setting, Mr. Hester. So he's on a short time period. So if we can't get something figured out on the 24th, probably won't be any more time granted to him.
Yes, sir. I understand. I would let the court know that there are some extenuating circumstances, and we could provide that to Your Honor in chambers at a later time. But I understand the court's concern. We'll make sure we'll cross it as fast as we can.
Just we'll see you back on the 24th.
Yes, sir.
All right, who's next?
Billy Schultz.
Billy Joe Schultz, CR 21-243. Show that Mr. Schultz is here on the motion for voting.
That's correct, Judge, and we also have Mr. Schultz already set on the 28th contested docket. I still have, we're not quite ready, but we're set already, so hopefully we'll have a resolution on the 28th, but we're not ready to proceed today.
All right, we'll see you back then on September 28th, week of Thursday.
I'll see you on Monday.
Yes.
Yes.
Who'd you say?
Mr. Calixto.
Lisa? James Lopez, Lisa, CR 19-10, motion to revoke. Go ahead, Mr.
Judge, same announcement, I think. Mr. Calixto is already set on the 28th. We hope to bring the court a resolution by the 28th, but not today.
All right, well, we'll see Mr. Calixto for contested hearing. All those dated and it's not resolved. Who's that?
What else? Again? No, he's already set on.
Who did you say, Mr. Schmidt?
This is Zachary Wooten.
All right, this is call number CR 22-56, State versus Zachary Taylor. Motions. Go ahead.
Judge, we're not ready to resolve Mr. Wooten today. I don't see where he's been set on the 28th docket, but if we can go ahead and set him on that date, we'll hopefully get her done.
All right, well, let's set Mr. Wooten for contested hearing if there's no agreement on Thursday, September 28th. This is Preston Wilson.
No, Mr. Wilson's not here at this time. This is Ryan Augustine.
Cause number CR 21-276. Mr. Augustine set for arraignment. I think we have one bench one for TDC, correct?
That's correct, Judge. We're ready to proceed to arraignment. Mr. Augustine's, actually, I would say that Mr. Augustine has been arraigned on this offense previously, and we were carried on the docket. I think we made it to pretrial. There is an additional offense, which I believe is indicted that I don't see on your docket, which he has not been arraigned on. It may be on the docket without my name on it because I was retained on the 276 case. But we'll go ahead and take care of the other one.
You haven't caused number for the other one.
I'm looking real quick.
Your Honor, I have CR 23-00043.
Yes, that's correct. That is theft of property, 30,000 to 150,000.
I see. It's on page 7. Okay, go ahead with arraignment on that one.
And Judge, Mr. Augustine's name is spelled out correctly. He understands the charges against him. We'll waive formal reading of the indictment, enter a plea of not guilty. I'll go ahead and make an appearance of record for Mr. Augustine on that particular offense, and we'll carry that one and the previously mentioned offense together and hopefully have a resolution pretty quickly.
All right, you want to set it on that October 24th?
Yes, sir.
All right, court says both causes for Mr. Augustine for pretrial hearing on October 24th. That would be at 1:30. Mr. Schmidt, did you say that you've been retained on both cases or just on the other one?
I was retained on the prior case, but if I would get appointed on the new one, so I'll just go ahead and make an appearance for both. No big deal.
Okay. All right, let's see, Mr. Augustine, get back on.
Yeah, Ash. Huh?
Have Dover and Preston Wilson.
This is still good. Oh,
All right, this calls number CR 21-59, State versus Ashley Bay Dover. Motion to revoke, go ahead, Mr.
Judge, we're not prepared to proceed on this over today. We'd ask that she be set on that 9/28 docket. Hopefully we'll have it resolved by then.
All right, court sets on Stover for contested hearing on September 28th. Unless it's. Who do we have left? Michael Shane Covey and Russ Wilson.
Good job. Everybody forgot about Mr. Covey. He's in isolation. At this point, I'd ask that he not be brought up, but that we set him for 9/28. There's a high likelihood that we're gonna have to go through the competency rigmarole again, so.
Okay.
Let's see what we can do.
All right, court will grant the non-appearance of Mr. Covey for today's docket. Court will set him for September 28th.
And I will let him know. He's in his cell, but
What did you say earlier about Mr. Wilson?
Mr. Wilson, I believe he's on his way up.
Your Honor.
Yes, ma'am. Yes, ma'am.
Okay.
Yes, ma'am.
Ready on Preston. Okay.
All right, this calls number CR 23-83, state versus President Mitchell Wilson, pretrial. Go ahead, Mr. Chair.
That's correct, Judge. We're gonna request an additional pretrial. I spoke with Ms. Curry as well as Detective Wheeler here recently. There's some ongoing events that may obviate some of the issues in Mr. Wilson's case, but at this point, we'd ask the court to give him an additional pretrial on the 24th of October.
Objection, Mr. Arlo.
No objection, Your Honor.
All right, court grants an additional pretrial on October 24th at 1.
Thank you. That's it.
Right, Your Honor, we believe that concludes our business.
Well, what about our status of federal custody on Joshua Lee Davis? Do we have any update with Mr. Schlamberg on that?
On who, Murray?
No, it's not yours, Mr. Schlamberg. It's attorney Schlamberg.
Oh.
Joshua Lee Davis, on page 8, status of federal custody.
Your Honor, I do have an update. Apparently he has been indicted but has not pled. Ms. Curry wanted to know if we could get another 60 to 90 day status check.
All right, well, let's set him on November 28th. I'll call it the prosecution. Status. Appreciate that, Mr. Harlow.
Yes, sir.
Brown Norris, we did, no. Mr. Schmidt asked if we just take that off the bench letter, so we reset to 10:24.
We can open.
All right, I believe that does conclude our after the doc. So thank you all for your work. I appreciate it. We adjourn. Good time.
We're waiting on Mr. Evans' papers and then we'll be over to get you to sign everything.
Yes, ma'am. So don't let Fabio touch the computer.
What do you say?
So don't let you.
Don't let me.